Well, welcome everybody today. I'm so excited that you're here. Carl and I are with Lawyers Title, and we are part of your affiliates in action here with SRCAR. Thank you so much to SRCAR for the opportunity today. We have some awesome guest speakers with Shoup Legal. If you don't know about Shoup Legal, they are local here in Murrieta, and I think that is just wonderful because they are not only great at their job and helping people, being a wealth of information for you and your business if you're ever finding yourself in a position where you need to help your clients with either trust or probate, or even if you're looking at an LLC for yourself in the future. But having someone here that you can talk to, go to an office if you ever needed to, they're just wonderful partners to have. So thanks again, Andrea and David, for being here today, and take it away.
Thank you so much. Well, we appreciate the opportunity. We love being able to talk with people and really share some information about it, because I think there's a lot of misconceptions and kind of bad information out there. So we like the opportunity to explain kind of what happens through probate, what a trust really is, why it's important, and all of that. So thank you for that opportunity. So just to take care of a little bit of housekeeping, I just want to make sure everybody can hear me. If you can hear me, if you could just type in the chat a Y or a yes, just so then I know that you can hear me, that would be awesome. Okay, perfect. I see that coming through. I appreciate it. Okay, I never know on Zoom and these calls. Sometimes I don't know, so great. So what you're going to discover today, so we're going to be talking with you for about an hour this morning, and the things that you're going to talk about is, one, how you can close your deal if it's in probate, some estate planning fundamentals for realtors, why vesting choices matter, also business law essentials, LLCs, corporations, what you need to know to properly advise your clients, and also I'm going to touch a little bit on Prop 19 and what you really need to know for that for your clients. So we got a lot of information to cover. Because of that, I really appreciate and enjoy taking everybody's questions. We're going to wait until the end to take your questions. And also at the end, we're going to give you an opportunity to be able to schedule time to speak with a member of our legal team as well if we aren't able to get to your question today. So you will definitely have an opportunity. We're just going to wait till the end just because we have a lot to cover this morning. So this is for you if you are sick and tired of getting wrong information, right? Again, there's some bad information out there, so this is going to clear the air of that. If you're concerned about making sure you have the ability and the tools and the knowledge to educate and advise your clients well, this is also for you if you want to make sure you have that right information for your clients. All right, so just a little bit about your presenters today. So I am Andrea Shoup. I'm an estate planning attorney. I'm actually a certified specialist by the California State Bar in estate planning, trust, and probate law. I'm very proud of it. I'm the only one in Murrieta and one of 3 in Temecula. With me today is David Shoup. He is our business law attorney, and he helps advise and help clients, our business owners, in making a lot of the decisions and making sure they're protected and the owners of those businesses are protected, be it a sole proprietorship and more often an LLC or a corporation. And then we have Carl Kujar and Marianne Shoup with the Lawyers Title team. And I will tell you, especially dealing with real property, it is so important that you have the right title people in your corner to make sure that your deal is going through and continues to the finish line, because it's so important. I like to say pull title early and often, because you got to make sure what's going on. So this is who is talking with you today. So first, we're going to talk about an introduction to probate. I'm often asked, what exactly is probate? You know, we hear about that, but what exactly is probate? So probate, a full probate process it's a court process. It's the court procedure for transferring assets from one person to another person after that person's passed away. Okay, it essentially settles their estate, pays off creditors, collects assets, and transfers it on to the next generation. It is a very lengthy process. On average, most probates take about 2 to 3 years to complete. And I'm adding that 2 to 3 years just because with COVID, we had shutdowns in the courts and we're still experiencing a lot of that backlog. In addition, the courts are closing down again every several Fridays of the month. And so it just reduces their ability to process our cases as quickly as we would hope. And so it's taking that much longer to go through that court process. It's also a very public process. Everything that happens in court is all public record. Everybody's assets and what we think of as fairly private information. Let's say, you know, where we bank, our bank account numbers. How about our bank account balances? It is all listed in public court records and documents and discussed in open court because the court process is a public process. It's also a very costly process. Probate is expensive, and I'm often asked, okay, well, what does that mean? How much does probate actually cost? Well, it is the court fees and the probate fees, rather, they are based on a percentage of the estate value. What do I mean by that? So when we look at calculating the probate fees, we look at the entire estate value, the gross estate value, meaning we look at a home and we just look at the value of a home. What does it appraise for? We don't look at a mortgage. We don't use that in our calculations. So if we have a $500,000 home with a $400,000 mortgage, the value of the home is $500,000. We don't look at that mortgage, okay? So for a fairly modest estate of, say, $500,000, probate fees exceed $26,000. And that's just for the sheer honor and privilege of going through this probate process that I'm going to tell you about. So it's a very costly process. You know, in a little bit, I'm going to tell you how you can help your clients avoid this process, but it's also important to know, okay, well, what is it when we have to go through this probate process? So when does probate occur? It occurs when somebody passes away and there is any real property. We have to go to a probate court when there's any real property. That's regardless of value, okay? It could be a, you know, $5 million property. It could be a $5,000 property in the Salton Sea, okay? It doesn't matter if there's any real property and somebody passed away owning that property, we have to go to probate court. Might not be the full probate process because there's a few shorter procedures we could do, but we have to get a court order. It also occurs when there are assets over $166,000 and $24 or $240 rather. That amount is adjusted every year now for inflation. So that just changed. It used to be, it was set at 150,000. So that has increased. So when there's property over, assets over $166,240, we are going through a probate process. So what do you need to know? How do you close your deal when we are going through probate? So the first question is, well, what happens when a property owner dies? What do we do? Really, there's no one there to sign the deed. That's the issue, right? If Bob Smith is on the deed and Bob Smith has passed away, Bob Smith can't sign that deed to transfer it. That's why we need a court order. There is a full probate process, which is what I'm going to talk about, but there's also these smaller procedures that are sometimes available. We can have a spousal property petition that is available when someone's spouse has passed. So sometimes people ask me, well, if it's husband and wife and husband dies, why didn't it just go to wife? You'd be surprised. A lot of times it doesn't. That's why vesting matters. That's why title matters. And I'm going to let Mary Ann and Carl talk about that in a little bit. But a lot of times, wife might not be on title. I've had that several times. Or husband might not be our title. Or maybe they took title wrong. It's husband and wife, but they didn't have the right words after their names. And so we have to go to probate court. So sometimes that spousal property petition is available. There are other procedures such as the affidavit regarding real property of small value. That is when property values are under $66,240. It's not a full probate process, but you still need a court order. So that's sometimes available. There's also a petition to determine succession to real property. That's when the property value is under $166,000 or $166,240,000. I don't expect you to, remember all these intricacies, but just know there are other options available. We might need to go to court and get a probate court order, but that might not be the full probate process. So this is, there are sometimes other opportunities and things we can do, and those are available. Another thing that is sometimes available is a Hexstead petition. That is when we've had a trust, but unfortunately the house wasn't in the name of the trust. So I don't know if anybody's experienced that, but if that is the case, many times with that, we don't need a full probate. We can go in and just get that probate court order through a Hexstead petition. Also, if there was a trust, but maybe we don't have a trustee, maybe all the trustees have passed away, we can go in and have a court appoint a successor trustee. So that's also an option that's available, and sometimes that's needed. So these are situations that occur when a property owner has passed away, where we might need a probate court order, but not need that full probate process and procedure. When we do need a full probate, there is no avoiding it. There is no shortcut around it. There's no way around it, because frankly, you know, and as they should, the title company is not going to let you close. They're going to say, no, Bob Smith, he's passed away. You need that court order. There's no way around it. You know, a power of attorney doesn't cut it, because a power of attorney, it extinguishes upon passing. So it's no longer in effect if that person passed away. So if a probate court order is needed, there's no way to avoid it. So an overview of the court process. So a summary of it is, and when we have to start a probate, we file our initial petition, and then we wait. After we file it, it takes about 60 to 75 days to get our initial hearing. And after that hearing, you know, assuming everything went well, and doesn't always, sometimes people object. Sometimes the court wants more information. Sometimes the person who was doing everything, they didn't get it all right, and they missed some stuff, and the court continues it. There's all kinds of different reasons. I'm going to kind of tell you a best case scenario. After that initial hearing, though, if the court grants the petition, which is always what we want, we get something called letters of administration or letters testamentary. That's when our letters are granted. Those letters, they're important. That's the authority. That gives someone, the executor or whoever's appointed by the court, the ability to sell the house. And that's where it's really important for you. You've got to make sure that letters have been granted, and you are working with the person to whom those letters have been granted. After letters are granted, within 4 months, an inventory and appraisal must be filed with the court. And then all the assets get marshaled, they get appraised, and any creditors issues are all dealt with and everything. And that takes a little while, unfortunately. I'd say about 1.5 years to 2.5 years later, then the final accounting and petition for final distribution is filed. So after that petition is filed, then we wait, you guessed it, another 60 to 75 days until we have our hearing on that petition for final distribution. Assuming all goes well, about 15 days later, we'll get our order basically closing the probate. Now, not all the time does everything go well. Sometimes things are interesting and the court wants more information. Sometimes people object. Sometimes people didn't do everything that they were supposed to and they get continued out. Many different things occurred during that time, but assuming it all went well, about 15 days later, that's when we are able to distribute all of the assets from the probate. And again, the part that you're really concerned about is when you're able to list the property, right? That's when letters are granted. That's when you're able to list the property and market it and sell it on the open market. I'm often asked, well, gosh, Andrea, that's a long time. Can't I just start marketing it beforehand? Can't I just go ahead and list it beforehand? Please don't do that. And there's many different reasons why. First, we don't know what a court's going to do. You know, I can tell you, I assume that letters are going to be granted at my hearing and everything, but a court might do something interesting. Maybe the family's told me everybody gets along and it's going to be fine, but then we have somebody come in and they're objecting and we get continued out. And then the listing becomes stale and it becomes old. right? And that's the last thing anybody wants for that property, because we all have the same goal and end purpose in mind. We want to sell this house for the highest value we can for our clients. So let's make sure that we're working together, and please don't list the property too soon, because it really does backfire. I would say then I've had conversations like, well, I'm concerned then they're going to go find another agent. Keep a good relationship with your client, but also keep a good relationship with the probate attorney. Make sure you're talking with them regularly and keeping in contact with them, so that you know, and everybody knows, hey, you know what, I'm the one who's helping this client with this listing. Whether we do it now or 2 months from now, then it stays with you. So I think it really is keeping good communication rather than jumping the gun on listing it. All right, so then some common probate terms. First is executor, personal representative, administrator. Yes, there are technically differences. For your intents and purposes, they're all basically the same thing. It's the person who's in charge of the probate. It's the person who has the ability to sell the house, sign your listing agreement, and ultimately sign the deed transferring the property. Okay, so that you've got to make sure that you're talking with the right person. That's the person who has that authority. Also, we have a probate referee. A probate referee is a court-appointed appraiser. We have to use the court-appointed appraiser whenever we're dealing with probate property. It just is. I get it. You know, people have 30 years in the industry. You know the market. I get it. It's just not going to work because the court has to appoint the appraiser. We got to use them, and we have to use their appraisal value when we're looking at how much we're selling the property. And I'll talk about that in a few minutes as well. What is an heir? An heir is the person who is by law the next to inherit from someone. Okay, mostly it's our children or our spouses. If we don't have children or a spouse, then it's our parents or maybe our brothers and sister. It's essentially the next of kin. Okay, that's who would normally inherit from someone if we haven't made changes ourselves. A beneficiary is someone we ourselves have selected. Maybe our beneficiary is our spouse or our children. Maybe we say, you know what? They'll be just fine. I don't want to leave my kids anything. I want to donate my house or my money to this charitable organization. Well, that charitable organization, whoever they may be, becomes a beneficiary. They're not an heir because they're not who would normally inherit, but it's who we've selected. That's the difference between an heir and a beneficiary. And then the next term is the letters of testamentary or letters of administration. Again, yes, there is a difference, but for your intents and purposes, they're basically the same things. That those letters, that's what gives somebody the authority from the court to act on behalf of the probate. So next, we're going to talk a little bit about what you need for your listing agreement when you're dealing with a house through probate. So, and where to get some information. So here is what the letters of administration or letters testamentary look like, the letters. So what it looks like, and this is how you can kind of glean from it the information you need. Many times you're going to need a case name. Well, it's right here. It's the estate of, and maybe it's the estate of Mary Smith, aka Mary Jane Smith. If you have pulled title, because I know you have, because you're pulling title early and you're pulling it often. If you have, you're going to find out, oh my goodness, the vesting deed says Mary J. Smith. But I don't see Mary J. Smith here. That is a good thing to be aware of and bring to someone's attention so that it can be fixed. Because when you go to close your escrow, if it's not identical, what's here on the case name on those letters and what's on that vesting deed, it's not going to go through title, because there is a difference. There is a difference between Mary Smith, Mary Jane Smith, and Mary J. Smith, and it has to be identical. But this is where you can find it. It's where it says estate of, that's the case name. The case number, it's right here, and you pull it right from where it says case number, and that's where you get that information. You also need to know who has authority. Who is it that has authority to act? It will say the court appoints, and it will have a name in there. Sally Miller. Great. Make sure you're talking to Sally Miller. If it says anyone else, you're not talking to the right person. right? So make sure you have the right person. This happens a lot. You're talking to the daughter. Of course, the daughter would have the authority, right? For mom, not necessarily, unless daughter's name is there, then daughter doesn't have the ability. Okay, and there's many reasons why a court may or may not appoint daughter to serve in that role. So make sure you check who has the authority. The next thing is whether court confirmation will be required. What kind of authority does someone have? So you find it here, and it will say the personal representative either has full authority or limited authority. And that's important because again, that will tell you whether you will need to seek court confirmation. Sometimes, even though someone has full authority, it might be required to seek court confirmation. Sometimes it won't, but it is important for you to know whether it will be required. Because what's the difference? Well, if somebody has full authority to act, no court confirmation of the sale of the real property is needed. Okay. And then if that's the case, then it's very similar to a normal listing. Yes, there are additional addendums and so forth for you to use in your listing agreement. And with the documents you give and the disclosures, there are additional forms and addendums to use. However, you're not worried to go back to the court for that court confirmation process. So that's why it's very similar to a normal listing. And you have to use the correct probate. I know the listing agreement changed, or you use the normal one, but with the addendums, you've got to use those additional addendums. And you have to use still the probate referee appraisal value. When there is limited authority, or no authority to sell the house without that court confirmation will be required for the sale of any real property. And it would be very different than a normal listing. And this is really where you want to work hand in hand with the probate attorney. Yeah, you should work hand in hand with the probate attorney no matter what, but you really want to get aligned with the probate attorney because you guys are on the same team, right? We want to get this house sold. And so work really closely with them so that you guys both understand the process. And you're still going to use the same the addendums when the property is going through probate and the appropriate addendums for that. And you're still going to need that probate referee appraisal, and it's going to be used a little bit differently. And I'll explain that in a second. So the California Association of Realtors, they have certain exemptions and requirements when a property is going through probate. So I've always found this very interesting. There are certain disclosures that are not required to be provided. Many times it's still good practice to comply with some of them. I've always found this very interesting. It's actually not required to have an operable smoke detector in the home. That said, still do it. There's no reason not to. And while it's not technically required, I'm sure there's other reasons, and there's plenty of reasons to still do it. So while it's might not be technically required and an exemption, it's still very good practice to make sure that it is done. But there are other requirements that still must be followed. Any disclosures and so forth. And I'll kind of tell you the reason why it's like this. So let's say it was, Bob Smith's home, and Bob Smith lived there, 40 years, but Sally Miller, she never lived there. She doesn't know that the back bathroom had a toilet flood, 3 years ago. So how can she really disclose that? Now, if she knows, she has to say, but she really can't go through all the disclosures that someone who's lived in the home will do. But I also think this is interesting. While the operable smoke detector is not required, the carbon monoxide detector is. I don't understand the difference. Do them both. It's good for everybody. It's safety for everybody. Okay, so the court confirmation process. The notice of sale must be published in a newspaper. It does require a hearing confirming the price within 30 days of the sale. The confirmation requirements must be met. There are overbidding requirements as well, and I'm going to talk about that in just a second. The overbids must be filed and in writing and filed with the court. There are special rules relating to the relationship that a broker or an agent can have to the buyer, as well as the relationship the agent can have to the administrator. So if you happen to be administrator of mom's house, you can't also be the agent, okay? And then also there's special rules regarding who can actually be the purchaser of the house. So for the court confirmation, it's important to have a good description of the property being sold because it needs to be put into that petition. The appraisal, the property when it's sold must be within 90% of the appraised value of the house. So you have to comply with that. If not, the court most likely won't approve it, or you have to give them really good reasons. You also have to know all the terms and the manner of the sale. For the overbid, there's a way to calculate the formula of the overbid. So for example, if let's say we have an original bid of $550,000, to calculate the overbid, it has to be 10% of the first $10,000, okay, $1,000, 5% of the original bid minus that $10,000, okay, that's another $27,000. You add all of them together and you have your lowest overbid. It has to be $578,000. So I'm often asked, like, how do you calculate that? That's the formula. That's how you go through and do that. So a few things: you must accept the highest and best offer. You've got to open up the listing to the open market. Yes, that means listing it on the MLS. Please do it. Please don't skip that. I've actually found myself in a situation where somebody did. They're like, oh, well, I posted a sign. Yeah, no, that's not sufficient. MLS, please. And also beware of the probate referee appraisal value. Again, that's that 90% rule. It has to, the accepted bid must be within 90% of that appraised value. In case you were wondering, oops, yes, you do need a certified copy of the order and copies of the letters. The title company will need that. A few more challenges when you have a property in probate, you have little access to funds and for repairs. Improvements might not be reimbursed by the court, so you really have to work with the probate attorney to know and understand what can be done and what should and shouldn't be done. The personal representative must adhere to the court standards using for decisions, and usually there's no help for cleanouts, junk removal, and so forth. But most importantly, remember, you are dealing with a grieving family many times, so you have to make sure that you remain flexible, right? Also, expect the unexpected and work closely with the probate attorney. Having a good working relationship with the probate attorney is very important and very useful for everyone, and nothing's final until it's final. And in case I haven't said it before, work with the probate attorney. So some resources for your seller: take the listing. You many times are one of the best resources. They're going to you for a reason, right? Because they trust you. So many times if you are working with a great probate attorney, you can get through the process of selling the house, even though someone's passed away, even though it's going through that probate process. Make sure you have an amazing title company. Mary Ann and Carl are amazing with Lawyers Title, and they will help you so that you know any pitfalls before you get too far down the line. Nobody likes to be 3 days from closing and find out, oh, guess what? Bob Smith passed away. No one likes that. Pull title early and often. You've got to have an estate sale company, a moving company, a cleaning company, a trash removal company, and contractors for repairs. So many of those, that is stuff that you already have as resources. After closing, you've got to ensure proper estate planning, because I just explained to you the probate process. It's kind of an in-depth process, and it's a very onerous process, and it's something that is completely avoidable. So another way you can be a great resource to your sellers and to your clients and buyers is making sure that they understand the importance of avoiding that mess, right? Because what really is estate planning? It's making sure we have legal access and legal information for ourselves, for our family. So if that unexpected occurs, right? If we pass away or we become incapacitated, we're sick, a car accident, we want to know who's going to step in for us and what are they going to do when they step in for us. The way we do that is with wills and trust and powers of attorney and so forth. Those are certain tools, but we've got to make sure that those tools are prepared well to make sure that our family does have the legal access and legal information they need to do what they need to do to step in for us. Some of the goals of estate planning is maintaining control, right? We want to stay in control of ourselves and our family because we want to decide who steps in for us. I want to make that decision, not some judge who's never met me or my family. I want to decide. I want to avoid court. I spent nearly 6 years in the district attorney's office and over 8 years in probate court. I go to court all the time. Nothing good happens in court. We want to stay out of court. We really want to avoid court at all costs because it comes with it of unnecessary delays, 2 to 3 years to have this settled. Could you imagine a grieving family who's lost a loved one and now they have to embark on this legal endeavor for 3 years? Gosh, talk about like ripping off the Band-Aid again and again. And we want to avoid unnecessary costs and expenses because when we haven't planned for ourselves, we are under the government plan, and that is not what we want. Nobody wants to be under the government plan because that is not a good place for us or our family. So we want to avoid probate as much as we can because it really is. It's the easy way or the hard way. And how do we avoid probate? That's where trusts come in. Okay, I'm often asked, well, why? What's the secret sauce? Trusts can completely avoid probate. Wills, they go through probate. Okay, wills are instructions to a judge. I'll talk about that in just a second. And wills go through probate every day, all day, every day. Okay, so wills almost ensure that someone's going to go through that probate process. A trust helps people avoid it, okay, because a trust is a different way to hold title to property. So who really needs a living trust? All property owners. That's why it's so important that you understand the importance of this for your buyers, for your sellers, because then you become that trusted advisor. We all are concerned about making sure our clients have the information that they need and what they need to protect themselves, right? So who have they been trusting for that information, that advice, by purchasing and selling their homes? You. So that's why it's important that all property owners have got to have that. Remember, any real property is going to go through probate court. You now have that knowledge, that information. Now you've got to educate and explain to your clients what will happen if they haven't planned. That's why it's so important. Also, all estates over that $166,000 to $240,000. Also, if anybody has minor children, they've got to have a living trust. They've got to have an estate plan. Planning for minor children, even if they don't own a home, is so important. As parents, I've got 4 little ones. My oldest is 8, okay? Yeah, 4, oldest is 8. So it is so important, us as parents. I mean, we plan everything for our kids, right? We like meal plan for them. Like we planned and make sure, okay, is your homework done? We're planning their distance learning. We're planning everything for them. We've got to also plan for what happens when it's not us who is there planning for them. Nobody wants to think about that or imagine that could happen. But as prepared and responsible parents, that's really what we've got to do. So it's important. Anybody who has minor children has got to have this done. Business owners, oh my goodness, it's so important. Many businesses cannot survive going through probate. I have a client right now. We're just finally finishing the probate after 14 years. There's a very, very valuable construction company in the probate, and unfortunately, it was valued at, I think, like $4 million when he passed within 4 months because the court could not operate fast enough. They can't get employees paid fast enough, get vendors paid fast enough, make sure jobs were being performed fast enough. The business essentially disintegrated, dissolved, and there is no business anymore, unfortunately. Also, anybody who has special needs beneficiaries, so if we have our children or family members have any special needs, it's important that there's a living trust for them as well, because we cannot jeopardize those government benefits that any special needs beneficiaries receive. So a little bit more vocabulary, some roles in a trust. Whenever we have a trust, we have 3 major roles. The first role is the role of the trust maker. Sometimes it's called a trustor, a grantor, a settlor. Those all mean basically the same thing. It's the person who creates the trust. That is the job of the trust maker. The second job is the job of the trustee, and their job is to manage this trust. They make decisions and follow the instructions in the trust. The third role is the role of the beneficiary. The beneficiary's job is to receive the benefit of the trust. They get to live in the house and enjoy the money in the bank account, right? During our lifetimes, we're all three. Okay, we are in control of our trust, we manage our trust, and it's still our house, it's still our money, we're still the beneficiaries of our own trust. Only after we pass away do our kids or whoever we've designated become the beneficiaries of our trust. Only if we pass away or become incapacitated does someone else step in as trustee. During our lifetime, since we're all three, we can remain in complete control of our property, of our assets, everything. So those are the different roles. The way I see it, the difference between the trustee and the beneficiary, the trustee's job is to write the check. The beneficiary's job is to cash the check. Yes, they can be the same person if you wanted them to. Sometimes like, well, I have my son. Can't he be the trustee and receive everything? Absolutely. No problem with that. So yes, they can be the same people. They just have different jobs depending on what hat they're wearing. Are they wearing their trustee hat or are they wearing their beneficiary hat? So with the beneficiaries, those distributions can be distributed according to your wishes. You know, I got my 4 little ones. They are not getting, everything when they turn 18, because that would just be ridiculous. Could you imagine any sum of money in the hands of an 18-year-old? That would be awful. Also, it's very necessary for special needs beneficiaries. A properly drafted, properly funded trust can completely avoid probate. So a trust can only control trust property. So how does something become trust property? You've got to fund your trust. This is where you got to make sure that there is a trust transfer deed showing that there was a transfer from, say, Dan Smith and Jane Smith, husband and wife, to Dan Smith and Jane Smith, trustees of the Smith Family Trust. Okay, this must occur. If this hasn't occurred, the house is not in the name of the trust. And that's why you pull title early and often, and you got to be in contact with your title reps to say, hey, can you pull this vesting deed? Hey, can I figure out who's on title? You got to know, because you got to know whether it's in the name of the trust or not. So what happens when you don't fund your trust? I'll give you a hint. It's probate court. Because it's not in the name of the trust, we don't have anybody to sign that deed, we have to go get a probate court order. And that's why wills are not enough, because wills contain instructions to a judge. They go through probate court. Also, a power of attorney is not enough. One, during someone's lifetime, a power of attorney, title companies, and rightfully so, they're a little skeptical of powers of attorney, because it's like, well, if this person's okay, why aren't they signing it for themselves? And if they're not okay, are we sure it's safe to allow this? So that's number one. Number two, after that person's passed away, the power of attorney doesn't have any power anymore. It extinguishes, it is done. So it's not enough. You've got to have a trust in place. Also, make sure that you don't let your clients do DIY planning, okay? There are plenty of websites out there, Susie Orman, LegalZoom, Rocket Lawyer, all kinds of stuff that gives us this false sense of security, this aura of protection that it's been done well. With so much writing on our family, for our family, our kids, who's going to take care of our kids, who's going to raise our kids, who's going to watch over their money, who's going to step in for us if we can't. Do not leave that to a Google search. Okay, you can't let your clients leave that to a Google search. You just can't. You've got to make sure that they do it well. I think one of the most telling examples of DIY planning gone wrong is Chief Justice Warren Burger. He's actually the Chief Justice of our U.S. Supreme Court a few decades ago now. But he wrote his own will. He did his own, estate plan. But he was not an estate planning attorney. And with all due respect, Chief Justice Warren Burger, he did it wrong. His son and daughter ended up paying over $450,000 in completely avoidable estate taxes and probate fees. And they had years of delays because of it. Everyone needs to really know and understand proper estate planning to make sure that it is done right. I mean, even a brilliant legal mind as Chief Justice Warren Burger got it wrong. You can't let your clients leave this to themselves, to a Google search or anything like that. So many of my litigation matters right now where there's fighting and just tens upon tens of thousands of dollars in legal expenses and costs and fees going down the drain because someone did it themselves, their own plan. It's awful. I actually had a situation, 3 brothers. The mom did her own will. I don't know which one she used, which website, but she had properly planned for all of her potted plants, who would water them, who would receive them after she passed and everything. She left everything else, including 3 pieces of property, to her oldest son to take care of his brothers. Well, what does take care of his brothers mean? Does it mean share with them? Does it mean like you get it all, but just, make sure that they're doing okay? Check in with them once a week? Like, what does take care of his brothers mean? Well, the judge didn't know either, and he stopped reading after to oldest son. And oldest son received 100% of everything. And you would think, well, come on, there's 3 brothers. Of course he shared with his brothers, didn't he? Of course he didn't. The 2 younger brothers, they got to see their older brother take their family to an Orlando vacation and start spending away the inheritance that should have been shared with all of them. And that is because do-it-yourself planning went terribly wrong. And what's probably the most tragic thing about it is 3 brothers will never be 3 brothers again. This one brother and these 2 have never had a relationship since then. And it's very sad. This happened probably about 4 years ago. It's tragic. So you don't want to leave this for your clients in the hands of a Google search or hoping, crossing their fingers they did it right. It's just not the way to leave our family. So next we're going to talk about why vesting choices matter. And we have Mary Ann Shoup and Carl Kujer to help us out with that. So if you guys can tell us why vesting choices matter so much.
Thank you, Andrea. Well, just as she was talking about, when you have a situation where it might not be, designated who is supposed to have interest in a property, or people want to take advice from their friends or their neighbors, or go down and file their own deeds, add all their children to title, put their sister or brother on title, and think that everything's going to be fine down the road. You just never know what's going to happen, and then what other people are going to get themselves into, and now all of a sudden they're subject to anything that they go do. So they have liens and any type of issues down the road when the home goes to sell. Now everybody is involved. When you go to take the listing of the property, you have to have everybody on title on board, and it just becomes so messy. Andrea, do you have that? There it is. Carl, did you want to jump in on this one?
Yeah, I do. Thank you, partner. Thank you, Andrea and David. This is always one of the favorite topics for people, but vesting matters in more ways than you can imagine, especially in a state like California where you have community property laws. And even aside from, probate and having a trust, essentially I have a motto that says, other than a trust, all roads lead to probate. So if you adhere to that, you'll never go wrong. But when it comes to title, the thing that makes vesting so important in a state like California is the fact that it is a community property state. So for example, when you have a sole and separate property, say Jane Doe, a married woman as her sole and separate property, oftentimes people will automatically assume because she's sole and separate, she's the only one that needs to be concerned with the property, or anything that would affect the property only deals with her. That is a fallacy. And unfortunately, unless the spouse, even though they may have never been on a loan, may have never been actually on a deed granting them interest by virtue of the aforementioned community property, they have an interest. Until they deed their interest to their spouse as sole and separate, if they get a judgment lien or anything like that, that's going to affect the property, and when they go to sell it, it's going to present a problem. Another one, tenants in common. That may be most common for when people who are not married, who are not family, but yet want to enter into the ownership of a property together. And that is a great way to do it. And it's a fractional base. So if John Doe, a married man, puts down more money, he can own a 60% interest in the property. And then Michael Smith can own the 40% property, and he is a single man. Problem in this, though, is if one of them dies, it really gets complicated. And I think Andrea and David can speak to that, in that 60% interest for John Doe would go to probate in that instance. So that would complicate matters, because you'd still have another 40% ownership interest in the property by somebody else, completely affected by his or her ability to sell because of this other 60% interest. So that's something to be mindful of when it comes to tenants in common. Then, and also with John Doe being a married man, again, the same thing applies to the sole and separate example, in that if that spouse never deeded their interest by virtue of community property laws, that needs to happen in order for it to be truly that person's interest alone. Jumping real quick, and then I'll come back. And I wanted to make sure I get this in. Andrea has said it a dozen times, and I am so grateful for her saying it, is pull title early and often. You've heard it. What does that actually mean? Well, if you're a listing agent and you get a listing, make sure you order what Marianne and I always advocate for. That's a listing prelim, because you want us to be able to help you identify these sorts of situations before you get it tied in escrow. And let's be honest, thinking about current market conditions, it's not taking a long time for properties to get put into escrow. So nothing could be worse than to put a property in escrow and then suddenly realize 3 or 4 days later, after you've got an accepted offer and buyer's earnest money deposit and everything of that nature, to find out it's got to go to probate. That's probably a bad situation. I'd be curious to know who's had that happen, because we've seen it before. But let us order a listing prelim for you. That way, before you ever get into escrow, not only can we start working on any title matters that need to be identified, we can look at the vesting and tell you exactly what's going to happen, because far too often the seller will tell the listing agent, hey, look, we've got a will. Hey, look, we've got a power of attorney. But like Andrea astutely pointed out, that power of attorney dies with the person granting that to the attorney in fact. So that's never a good thing. But unfortunately, it's a misconception held by so many, and it creates problems. Jumping back in, oh, by the way, and then the early and often part, I'm sorry. So you get the listing prelim. We help you identify the vesting and any other matters. But the often, once you have that listing prelim, please remind us, and we need to update that prelim every 30 to 45 days for you guys, because unfortunately, when there are situations where the homeowners have passed, it's not uncommon for things like the property taxes to go unpaid, or a creditor that was not known to go to a judgment lien, and suddenly for that to show up as well. So those are things that will affect your escrow. So the often part is updating that prelim and making sure that we are getting that to you on in a regular basis. Jumping back into the vesting, joint tenancy is probably the most common, and that has advantages. But again, if it's not in a trust, if both the husband and wife as joint tenants get killed, unfortunately, in a car accident, for example, then it's going to have to go through probate. The other one that is also tied really closely to that is community property with rights of survivorship. And truly, from a title perspective anyways, it's almost the same thing. And maybe Andrea can clarify, but our perspective on is the difference between that and joint tenancy, really, truly, and then talking to attorney, is it basically has the same effect on title. It just affords the owners a few more tax advantages. So that's truly the difference between joint tenancy, in my professional opinion. But those are the basics of vesting matters. Does anybody have any or I'll throw it back to you guys unless somebody has a question or you want to clarify, Andrea or David.
If anyone needs copies of this flyer or access to grantees, send us an email at kstitleteam@LTIC and we can help you guys out anytime.
Can I give one more example real quick before I go? I know I'm long-winded. this slide right here, adding your child to title is a bad idea. There's an example that I've probably told 150 times, and it bears repeating. A perfect example of this is, before I cede the table, the floor, dad owns a property, his sole and separate, his spouse had deeded off years ago, granting interest to him. He truly is sole and separate. Years go by, for some unknown reason, he adds little Johnny to the property. Little Johnny is deeded on. He has an ownership interest in the property for 2 years. For some reason, unbeknownst to us, we don't really know why, little Johnny deeds back to dad. We're going to close. We get the SI, statement of information. We see little Johnny has an ownership interest. We run little Johnny's name. During that 2-year period where little Johnny is on title, little Johnny quit paying his car payment and it got repossessed, and a judgment lien in favor of Ford Motor Credit was recorded. Guess what? 3 days before escrow, we find this out. Guess what has to be paid in order for us to close? Little Johnny's Ford Motor Credit judgment lien, because he held an interest in that property at the same time that recorded judgment lien went on the record. So adding your children willy-nilly back and forth, in addition to judgment liens, also creates uninsured deeds. Anytime a deed is recorded outside of a transaction that's a refinance or a purchase where title insurance is issued, is considered by title companies across the board to be an uninsured deed. The reason being is that anybody can go down to the recorder's office and record something. The recorder looks for certain things. They're not attesting to the validity of the document itself. So title has to verify that the person deeding away their interest or adding interest to somebody else is truly what their intent was, and then has a valid document. So, and that creates problems, especially down the road years later, where a deed has been done and now those two parties don't necessarily get along anymore, and we have to have them execute an affidavit of uninsured deed. So that's my 2 cents on that.
Yeah, and that's why, I mean, really, truly, I mean, title really does matter. I see people wanting to add a child to their property to kind of circumvent the need for a trust. You know, it's one of those things, it's, you know, an ounce of prevention is worth a pound of cure, because it, as Carl said, it creates so many issues. I mean, we've had people where mom and dad, they're now responsible for son's dog because the dog bit someone. I mean, it gets really messy, and the uninsured, you seem to answer a question, but you really don't. That's why we want to be able to talk with you so you can advise your clients and don't let them do that, right? Friends don't let friends record their own deed and add their kids to title, because it's so important to make, and it has such a huge impact. So you've got to make sure that it's done right. And you, as that trusted advisor, you know, can advise your clients to make sure that it's done right. So next we're going to talk about business law basics, and David Shoup is going to help us talk about that. David.
All right, it's my turn now. So I'm going to give you guys the crash course on what you need to know about 2 of the most common entities that you're going to run in contact with, not only for yourself, but for your clients. And the first one, it's right on the screen. It's that limited liability company, okay, otherwise known as the LLC. All right, this truly is an amazing vehicle for real estate, which is, let's be honest, what you guys really care about, right? Those rental properties, those commercial properties, what those transactions that you're assisting with, those kinds of things. It's really, really good to use that LLC for this. But you may come in contact with various other kinds of entities, limited partnerships, family limited partnership, that kind of stuff. That's not really that common anymore, okay? Because of the LLC. All right, so what I want you guys to do is really just understand when to have these questions, when to have these conversations with your client, where in that timeline, okay, are these questions properly asked, so you can make sure that this is set up or assist in this being done properly for your clients, okay? Remember, when we're talking about the LLC, we're talking about commercial property, we're talking about rental properties, either commercial or residential, and the LLC is really, really good for protecting the property owner from things that could happen to the property, okay? So I got here on the screen, when you're talking commercial property, it really should always be in an LLC. Commercial property, the way I describe it to my clients, has no business being held in individual names. Okay, there's just too much risk. There's too much things that could happen on commercial properties, especially if it has, you know, vehicles on it, you know, maybe some construction components or something like that, that really should never, ever be held in a person's individual name. So what I want you to do is make sure that when you are talking with your buyer or with your client, et cetera, that you're saying, okay, how, you know, where's this, how's this going to be owned, right? So you're buying a commercial suite, maybe a building, something else, some kind of condo or whatever for commercial purposes. Really need to talk with an attorney to get that LLC set up before you go into escrow, okay? I've gotten calls where people are frantic in escrow. Oh my gosh, I need to get this LLC set up. And it's just like this mad dash. We got to update escrow documents and this whole nonsense happens. You want to pre-plan this, okay? So get your clients over there to get that LLC set up before they go into, before they open escrow, okay? Now, with residential rental properties, or we're not talking about the home, okay? The home is in the trust, right? Andrea's gone through that. The home is in the trust, all right? But with other residential rental properties, it's not a clear rule, or it's really just always in an LLC. Sometimes it is. Sometimes it isn't, okay? This really needs to be strategized with an attorney to figure out whether we should use an LLC or whether we should not, okay? So when we have out-of-state rentals and we may not be there, the client's not gonna actually be there with the property, it's gonna be managed by someone else. That's a great example of when an LLC should be used, right? If we've got a number of residential, like single-family residences, and we're just going to be accumulating a lot of these properties for an overall investment strategy, that's a great example of when an LLC should also be used. If I've got a house right next to mine, right, and I'm going to rent it out to a family friend or something like that, nah, probably don't. Probably, I mean, you could, right, but you may not need it in that circumstance. It's just a lower risk. If you're using Airbnb, okay, you're getting people in and out of there every other day, that should be in an LLC, because they're just all these new people that are going to be coming in contact with the property. There's just a lot more risk. It's all about managing the risk with the LLC, and I'm going to explain how the LLC can protect the property owner right now, okay? So here's a quick diagram, okay? You got on the very top is the property owner, you got the personal home, the personal property, and then you have the rental, okay? Commercial, residential, whatever it is, it's on the left side, okay? And then let's say a pipe breaks or something happens in the property. Maybe it's a $500,000 worth of damage. 250 of it is covered by their renter's insurance, and then you got $250,000. What is going to happen with that judgment? Okay, if your client owns it in their own personal name, that is their personal debt. Okay, they're going to go after their personal home, after the rental property, and really everything else that they have to satisfy that $250,000. Okay, what we want to do is shield themselves personally from that $250,000. Okay, so this is what it would look like. The next slide. When you have an LLC, okay, so we have this real estate holding entity. That's really what it is, okay? This LLC is designed specifically to hold the rental property or whatever it is that's going on, okay? So now the difference here is that that rental property is going to be in that LLC, and then when that lawsuit comes in, for that same example, the pipe burst or some kind of, you know, damage to the property, or someone slipped and fell and hurt themselves, and whatever's not covered by that insurance, obviously, nothing I'm saying means don't get insurance. You get yourself properly insured, right? I mean, that's step one, okay? But you don't want to just rely on the insurance. You want to make sure that your client's protected. And so what happens when you have the LLC is that lawsuit's going to come in, right? And it's going to eat up everything in that LLC. And then it's ideally going to stay locked into that LLC. It's going to stay isolated from everything else that the property owner buys, okay? So a common question is, well, how much should I have in the LLC? Should I have multiple LLCs for different properties? This is a case-by-case basis, okay? I mean, really, it depends on the risk for that property. Do we want to put a bunch of all these different properties in an LLC? Maybe we want to divide them up, you know, that kind of thing. That really just depends on how much risk there is per property. But the general rule is we want to protect our clients from the risks of the real estate that they're buying and investing in, okay? All right, so here, now we're going to talk about the next entity. And this is the other entity that you're going to come in contact with is the corporation, okay? Specifically, a particular kind of corporation called the S corporation, okay? And what the S corporation is just a way of taxing the corporation that's better for taxes, you know, that kind of thing. Okay, I'm not going to go much into detail on that, but the reason why you're going to come in contact with this entity a lot is because this is the entity that realtors use to pay less taxes to the IRS by owning and operating a corporation and flowing their commissions through this corporation to save money on taxes, okay? So this is why you're gonna come in contact with this. The corporation is not for real property, okay? No, the LLC is for the real property. The corporation is protect the business owner. And guess what, guys? As a realtor, you are a business owner. You are likely operating right now as a sole proprietor. You're being paid by 1099 from your broker. Okay, what you want to do, you want to change is that this corporation will receive the commissions from the broker, and then you pay yourself from your corporation. You have all kinds of really cool tax planning strategies to reduce the tax liability, the self-employment taxes that you're paying right now, okay? So while your CPA will need to advise you as to whether or not you should incorporate based on the income that you're earning, a general rule of thumb is that if we're grossing over about 75 to 100,000 in our gross commissions, or we're profiting over 25. And again, this is just a broad summary of all the CPAs that I've talked to, the dozens and dozens of CPAs that I've talked to. This is basically the average that the CPAs will tell me, David, I want my client in a corporation. I want you to get that going because we want to reduce their tax liability. Okay, so that's at the end of the day where the corporation comes into play. Okay, so LLC for the real property before escrow is open. Really, when you're making that initial offer, get that LLC set up, and then the corporation to protect yourselves personally and reduce your tax liability. Okay, one more note. When it comes to incorporating or setting up that LLC, timing is critical as far as when in the year that you're putting this together. Okay. Very unlikely that you're going to want to put together an LLC right now unless there is some significant deal that's going through, because there's something called a franchise tax board. You're going to pay taxes even at the very end of the year, $800. But if you wait to the very end of the year, January 1st, there's special rules that come into play where you can avoid that franchise tax board fee. Timing in the year is everything to avoid taxes. And so you want to make sure that you consult with an attorney before having this set up, or all of a sudden your client is going to get this $800 bill for only getting use of their LLC maybe 5 days out of the year. So don't just start filing stuff, right? Don't just tell them, oh, just go on to LegalZoom and just take care of that. Andrea's talked about the dangers of do-it-yourself planning. The same applies to setting up a business. You want to make sure it's done properly, done correctly. So there you go. That's what I got.
Awesome. Thank you, David. So next, I'm just going to touch very briefly on Proposition 19, because I believe it's so important for anybody involved in the real estate industry. So Prop 19 contains two very big relevant changes in how property taxes will be assessed whenever there is a transfer. It significantly changes the parent-child exclusion for property tax reassessment and when that is available. It also has changes regarding the transfer of the taxable assessed value of a property for certain property owners. So this was a big change that just happened with this last election, and it will go into effect on February 16th of 2021. So what do you need to know? One, whenever property is being transferred from parent to child or grandparent to grandchild, if the child has passed away, then the ability to exclude that transfer from property tax reassessment is significantly limited. It's limited to only if the real property was the residence of the parent and will be the residence of the child within 1 year. And it's also limited as far as how much of the value can be excluded. There's a complicated formula. I'm not going to get into that. There are ways, what you need to know is there are ways that your clients and their children can save money on their property taxes in the future, but they have to act now. They have to act before February 16th of 2021. If not, it's done. this is going into effect, and it will significantly change how property tax exclusion and transfers for exclusion from reassessment occurs. So what you need to know is that they've got to do something now and get it in place, done before February 16th of 2021. So what we are doing to, because there's no way I can go into it right now, we are having a webinar on December 15th at 4:30. You can sign up for that. Just go to www.shouplegal.com/prop19. You can sign up. It's a free webinar, but sign up for it so that you or your clients can get this information. We're going to be explaining how Prop 19 affects property tax reassessment, how that is going to affect us in the future, but what we can do now, the strategies we can implement now, so we can stay under the previous law and make sure that we are protected and our clients are protected. So it's, again, I just don't have enough time to go into it now. We're over, and I appreciate everybody sticking with us right now, but that is available. So go and sign up for either you or your clients. All right, so David, if you want to talk about the strategy sessions that are available.
Absolutely. Now, Andrea, when would you like to take a couple of questions on probate? We had a couple of questions.
Yeah, you know what? Right after you're done with this, I'll be able to answer whatever questions there are.
Okay, guys, so here's the deal. You're probably feeling right now like, oh my gosh, this is a ton of information, probate and listings and trust and what kind of trust and businesses. And I mean, it's just, we really wanted to give you just about a mile wide of information, and you may be feeling overwhelmed. So what I want you to know is that you can schedule a personalized strategy session with a member of the Shoup legal team to continue to ask these questions. Maybe you got questions on Prop 19. Maybe you got questions on your LLC or corporation or your living trust. So we've developed a specialized strategy session for you guys, okay, to come in and talk with us, okay? So I'm gonna tell you a little bit more about how this works. This is a 45-minute meeting with a member of the legal team of Shoup Legal. This can be done over Zoom. Okay, so it doesn't really matter where you guys are, you Zoom, phone call, or in person. And then that's the first part. Keep on going. So we're going to we're going to give you additional training on how to discuss these topics with your clients, okay? We'll even help practice that with you so that you have the language that you need to talk about estate planning and probate, et cetera, with your clients, so you can be of better value to your community, okay? That's really what this is about, is helping our community, and we're gonna help you do that, because let's face it, you guys are on the front lines, okay? We're here, you guys are out there, right? So when you're out there, we're gonna help you be a better value to your community. And also, you may have your own personal concerns about your own situation, perhaps, by yourself. And so we're not gonna leave that, we wanna cover that as well. So your own concerns and the specific goals that you may have, we're gonna talk about that as well as helping you develop a strategy for your family and for your business and growing that business, like we said, or like I said, you guys are all business owners, right? And then whatever questions you have, we will answer that for you. So that's what we're covering in our strategy session. Okay, so at the end of our time together, you're gonna have that clear plan of action in place. All right, so what I want you to do is, and we're gonna be going through how to protect your family business, like I already said. Okay, so what I want you to do, if you wanna take advantage of this strategy session, again, we wanna be available to you to help you, again, provide that value to your clients, okay? So we are making ourselves available to you. I really encourage you guys to take advantage of this, all right? Message Andrea Shoup, okay, or myself, obviously, but really, let's just send the messages to Andrea so they're all in one spot. Message Andrea Shoup your name, your email address, and your phone number. It's only seen by us, so don't worry, it's gonna be private. And then we're gonna reach out to you to schedule your strategy session, okay? Once you do that, you're gonna receive a confirmation email, and you do not need to prepare. Okay, that's really critical. However, if you have an existing estate plan and you're wondering yourself, is this any good? Will this protect my family? Is this properly updated? bring it, okay? We will take a look at it, all right? We'll take a look at this, and if you have a corporation or an LLC, bring those documents in, okay? We're really ramping up what this strategy session can do and what it really, I just wanted to help you as much as possible. So bring your stuff in. If you were to call in outside of this webinar, outside of this workshop, it would be a minimum of $450, all right? Typically, these review sessions can be a little bit more expensive, but what I want to do is make my team available to you. There's no reason for you guys not to take advantage of this strategy session, okay? There's no reason. It is completely free, okay? I can't make this any better for you guys. It is completely free. Send your information to Andrea and we'll get you on our calendars so you can come in and talk about this stuff. Even at bare minimum, just give you some additional training about how to discuss these topics with your clients, okay? So what's the catch? There is no catch. There's no catch here, okay? The only limitation is truly our availability, okay? We have reserved a set amount of time for you guys for the remainder of the year and then into next year, but we really need to open these spots up for our other clients and for people who are calling in. So we just need to know today whether you are interested in taking advantage of the strategy session or whether you're not. So just send that message so that, again, we can open up our time to other people in our community to help them. But like I said, there's no reason for you not to take advantage. Just give us a call. We will help you, okay? We'll sit down with you, help you answer your questions, okay? So, okay, reiterating again, message Andrea, your contact information, and we'll be in touch with you, okay? If there's a preferable time of day that you need, for example, I'm not gonna be available until 3 o'clock, call me then, please just let us know so that we're not leaving voicemails and we're just playing phone tag. An additional part of this is that we have a lot of printed material that we would like to give you. So when you come to your strategy session, we're gonna give you these brochures and things like that you can use with your clients to, again, just be of better value and get the information out about these topics for you. So attend your strategy session and this is all yours, okay? Okay, next slide. So there you go. There's your personal strategy session, training strategy session. Come on in. I would love to meet with you guys one-on-one. Andrea and the other awesome other attorneys here at Shoup Legal. Really looking forward to meeting you and helping you guys out, okay? So there you go. All right, so if you have any other questions, all right, we got a lot of messages in the chat about, if I have other questions, what do I do? Give us a call, right? Give us a call. We will speak with you. We will help you. You can also email us at info@shouplegal.com. And then Carl and Mary, their contact number, they are amazing, okay? They really, really know title in ways that I could not even fathom, okay? So they are truly experts. Give Mary Ann and Carl a call. Their number's right there, and also their email address is right there. So again, we will be resources to you. Okay, Andrea, we got some questions now, okay? So thank you so much, everyone, for waiting. We got a couple of questions, so we're just gonna get right into it. A lot of them are very probate specific. Okay, first question. Can a common law marriage be determined after the death of the asset holder, or would the heirs have more standing? And then the example was a long time live-in girlfriend of 20 years. The man died and the kids are wanting the property. So I know that's pretty complicated. Any guidance on that one, Andrea?
Yeah, so I will say there is no common law marriage in California. So it doesn't matter how long people have been living together. It doesn't matter if they held themselves out as husband and wife. If they were not married, they are not husband and wife. And so unfortunately, that long-term girlfriend has no rights. The kids are the heirs. Remember, right? We talked about that next of kin, who the heirs are, the next of kin. It's the kids, it's not the long-term girlfriend. So unfortunately, in that situation, there's no common law marriage. She's not a natural heir of the person who passed away. So not good news for that person. Okay, what other questions?
All right. Second question. If the court confirmation is required, when would you need to list the house? After the letters or after the appraisal?
Yeah, so you're going to, it's actually going to be both. So you would need letters to be able to know who's going to have the authority and that they do have the authority to list the house. And it's a good idea to get the appraisal done. And maybe not so much before you list the house, but before you finalize the deal or get too far down that road. Sometimes they're kind of happening at the same time. So what happens is once you get your letters, then you find out who your appraiser is, the court appointed one. You send everything to them. They usually have 6 weeks to get it back to you. So you don't have to like sit on your hands during that time. You can do stuff, but you've got to make sure before you have the offer that is accepted, and that's kind of like your offer or, you know, your deal, that, you know, it complies with that 90% rule for the appraisal. I haven't seen any major issues with that, and definitely not in this market, not what's going on right now. Several years ago, we had a few issues with that, but it's really, I haven't seen many issues with that. But definitely that is a great reason also to work very closely with the probate attorney so that everybody's on the same board. So, and if they're saying, you know what, I'd rather you hold off a week or two to list the property, hold off a week or two. You know, it's better to not, you know, make friends versus not, because you guys are on the same page. You guys want to work together, not just for this deal, but then in future deals as well. So go ahead.
Great question. Great answer. Can the probate fees come out of the proceeds from the home sale, or are they upfront costs?
Yeah, no, that's a great question as well. So many times, well, most of the bulk of the probate fees are paid at the very end of probate. Usually it takes a little bit to get started. Every case and situation's different, and frankly, every attorney's different. But there's like initial filing fees, publication fees, and so forth. Usually that's about $1,200 to $1,500 just to get the case started. So that's usually what's required at the very beginning, but the bulk of everything does get paid at the very end. And that usually ends up coming from the pool of assets, including the proceeds from the sale of the house.
Outstanding. Do you need a probate even if you have a living trust?
Great question. So a properly drafted, properly funded trust, you shouldn't. Sometimes we find issues, and sometimes the trust is just not sufficient. And that might require us to go to probate court. Maybe not the full probate, but probate court. Maybe if the property wasn't in the trust, then again, we might need to do a full probate. Maybe we could do a hexa petition. It depends on how good or not good the quality of that trust was. I mean, and that's really where, you know, the quality of the trust and the documents really matters, because sometimes, to answer your question, sometimes it's very simple. Absolutely not. You don't have to go to court at all. It's very simple, very easy to go through and well done. The flip side is sometimes it is a mess. And not only do we have to go to court to fix the trust, but we now need to go to court to make sure the property's in the name of the trust. And that's why, you know, you got to make sure that your clients aren't, you know, the DIY planning.
Absolutely. Okay, last question. Is it best to wait for the appraisal to come in to list, or list once the letters have been granted?
So again, you want to wait until the letters are granted until you list the property, and definitely be working with the probate attorney to make sure that you guys are in alignment with when it's going to get listed. I say right after the letters are issued, that's usually when we can list the property. Definitely not beforehand, but make sure you do it, you know, have the letters, then list.
Okay, if there's no other questions, I think that about does it.
And you know, I highly suggest, you know, book a strategy session with us. You know, we really appreciate the everything that really that Marianne and Carl is doing for not only our community, but for the, you know, realtor community, but also we love everything that this organization does. I appreciate the opportunity to talk with everybody, but SCR, you know, it is so amazing everything that you guys are doing to support our community and help. So to honor that, that's why we're making these strategy sessions available to you. I know it's a lot of information, and many times you will have questions. Again, please go ahead and message me to book a strategy session. Just give us your phone number and email address so we have a way to contact you. Our assistants will be reaching out to you between today and tomorrow to book it. We have time booked out, as David said, till the end of the year and in the first 2 weeks of January. it's completely available to anybody who's interested from this session. We just have to release that those times, just because we have to make it available to the other clients who want to come in to speak with us as well. So that's the only limitation. Just let us know. You can send me a direct message. So on the chat, if you see the chat, it'll say to. Instead of saying everyone, just find my name. I should be right there at the top. So it's Andrea Shoup. Click my name. And then you can send a message directly to me. I already see several of them coming through. But if you have any questions, Marianne, maybe we can unmute everybody in case they are having issues with it. They can speak up and let us know that they're having issues figuring out how to do the chat. With the Zoom, I love Zoom. It's been a great way.
Andrea, you are muted. This is a great example of what you're talking about. Sometimes Zoom doesn't work.
Oh, look at that. Somehow I got unmuted. Or I got muted. Sorry about that. No, but so, I mean, Zoom really is great to allow us to communicate and engage and interact with each other. But sometimes, figuring out the chat and this is a little bit of a challenge. So if anybody has been having trouble with getting a message to me, just let us know. So go ahead and let me know right now. Anybody having trouble with that? Nope. Okay, good. All right, perfect. Yeah. So we're going to be finishing up here. Thank you so much, Carl and Mary Ann. Thank you so much, SRCAR. We appreciate you, and thank you for the opportunity.